consecutive YouTube live presentations. And good morning to you, Janice. So Janice, I think you've been on most of them. Nice to have you here. Feel free, all of you, to be chatty in the chat box. Just having some fun here, using some free time to educate, to learn. So all good stuff. All right. So here's what I want to go over today. Topic of the day is, should you use a will or a living trust to provide what you have, for your survivors, for your family, for your loved ones? Just some housekeeping before we get started. This is day 6. We started Sunday. Here's Friday. I feel like it's been really an overwhelming kind of success on these YouTube live presentations. What has happened is usually maybe 20 or 30 people, maybe 40, join on the presentations, live during the 30 or 40 minutes that we do it. And then, 200-300 more, and more will continue to watch it on the YouTube platform. So I like the YouTube platform. It makes it easy for me. The pros of it are, I basically just set it up and turn it on, and away we go. I don't have to have any technical skills. But what I really like about using YouTube as the platform is YouTube records it and then makes it available to the public after, without me having to lift a finger. The downside of using YouTube Live on these presentations is it's really just a talking head video. I can't show you a screen. If I wanted to pull up something on my computer and show it to you, I can't do it on this YouTube Live format, but that's okay. We're making the best of it. All right, so here we go. Today is this will or trust. It's probably the most discussed issue, at least in my state, regarding, how should you leave stuff to your survivors. And yeah, there's lots of other decisions, how you leave things to your spouse if you're married, how to leave it to the kids, whether to leave things equally, whether to leave specific things to specific people, whether to include grandchildren. If you have, blended family situations, how do you do all of that? Do you do the legal documents the same or different from your IRAs and your life insurance and all that beneficiary designate? There's just a whole host of issues that we bring up. But this one, really, will or living trust is kind of a hot topic, especially among I think the lawyers. I will say before we get into it, and this may be just a notch over some people's heads, maybe not, is in many other states outside of Louisiana, California might be one, Florida might be one. The living trust is just the absolute no-brainer. And I'm pretty sure the reason everybody in that state goes this living trust route is because in states like California, the alternative of having a will and going through the court process, it's very expensive, and it takes a very long time, and it's very complicated. So those are no-brainers. But here in our state of Louisiana, I think you've got lawyers in both camps. Some will say, nah, people don't really need living trusts. You can just have a will, and then the family goes through the court process when somebody dies, and it's not going to be that bad. It's kind of not going to say on this YouTube live presentation that you should have one or the other. I just want to educate pros and cons, consequences, features, benefits, and then you make the decision. So the way I'm going to do it, probably going to take about 20 minutes here, is the way that I'm going to do it is I am going to give you 2 examples, 2 stories on what would happen when a couple, and I'm going to use a married couple situation here as opposed to a single person. What would happen when a married couple sets things up through their wills to leave things a certain way to each other and then to their kids? And then I'm going to go through a scenario where a married couple sets up a trust to leave things to each other and to their kids. What's the difference? So I'm going to go through the will story first. I'm going to go through the trust story second. It's going to be slanted toward the Louisiana version, but I'm going to try to give you a scenario that's fairly normal And then give apply the numbers to it and expenses and time periods, and then you make the call from there. So here we go. Let's jump in. So first, I got to give you a hypothetical married couple. Let's say they have 2 kids. We'll call the couple Dave and Martha. And I use Dave because it starts with a D, and sometimes I say dad and mom. I'm going to say Dave and Martha. And let's say they've got 2 kids, Linda and Randy. No real reason why I picked those names. And it is a fairly normal family, if there is such a thing. Sometimes I tell people I've been doing this for 30 years, trying to find my first normal family, and I haven't found one yet. But let's say Dave and Martha are that one kind of normal family. And so before we get into the specifics, let's talk about their situation. Let's say they live here in Louisiana. And let's say their assets consist of, maybe a little bit more than the average Louisiana couple, but not much more. They're not super wealthy. They're not worried about the estate tax. Clearly, they'll never have 11.58 million. That's not a concern. But they have a home. And let's say they have another piece of rental property. I'll tell you what, let's say they own a piece of property at the beach. Maybe it's in Alabama, maybe it's Florida. Heck, they're probably there right now because I think Florida just opened up its beaches. So they have their house, they have a piece of rental property, could be residential rental or could be commercial. They have some joint brokerage accounts, let's call it, at 2 different financial institutions. They don't have all their eggs at one financial institution. They broke it up and they have 2 financial advisors, and so they have brokerage accounts at 2 different financial institutions. And then they have their IRAs. Maybe they each have a traditional IRA and a Roth IRA. And then they've got things at the bank, things like checking account, savings account. Maybe they even have a couple of CDs at the bank. And like everybody else, they got a couple of vehicles. So that's what they got. And their goals are, again, kind of like the normal traditional family. They want to stay in control of what they have. When one of them passes away, their primary objective is really making sure that the survivor of them kind of stays in control of everything. Really, nothing goes to the children until both spouses pass away. But when that happens, they'd like to do what they can to, maximize what would go to the children, make it as easy on them as they could. Let's say another typical scenario, one of their children, Linda, lives locally with them, not with them in Louisiana, but maybe a few miles away from them. And then their son, Randy, work took him out of state, so he lives in another state. But they want to treat their children equally. Yes, Linda is local with them, so if they've got jobs to dole out, that really should be Linda, but they want the financial interests and the inheritance to be 50-50 between Linda and Randy. Okay, so that kind of lays it out that there. It doesn't really matter to me what the total net worth of their estate is. But, if they got a house and a rental property and they got a place at the beach and they've got investments, let's just say, just so we can kind of put a number on it, let's say the total of everything that they have is worth, let's call it $2 million. So that's what they got. All right. And so what I want to go through next is we'll take a few minutes going through they're in that process now of wanting to get all of their legal affairs in order. Let's say Dave and Martha are at this moment, 60 years old, and their kids are adults. Their kids, if they're 60, their kids are probably in the, early 30s, something like that. All right. So let's look at what would happen if they go what I call the will route. They go see a lawyer. Their wills in general, each of Dave's will and Martha's will, they're what I call, or what people call, reciprocal wills. Dave's will said, I leave my entire estate to my wife, Martha. And then it also says, if my wife, Martha, predeceases me, then when I die, I leave everything 50-50 to Linda and Randy, our 2 children. And Martha's will says the same thing. Martha's will says, I leave my estate to my husband, Dave. However, if Dave predeceases me, I leave my estate when I die equally to my two children, Linda and Randy. Both of them in their wills, they named each other as the executor. They named Linda as the alternate executor to handle things after they both passed away. Again, they picked Linda because she's local and she knows all their stuff, and so it was just appropriate for Linda to be that person to be able to do things like sell the house and deal with their accounts after Dave and Martha pass away. So that's what the wills say, and they decided to go the will route. And in a minute, we'll put Dave and Martha through the trust route. But for now, Dave and Martha chose to have wills, either because that's all they knew, or kind of that's what the lawyer said they should have, or their best friends had wills, and so they got wills. Doesn't really matter the reason why they went the will route, but they did. All right, so now things are set up. They've got their wills in place. Yes, they also did the powers of attorney, all the healthcare documents, but we're really focusing on this, what happens when they die scenario. So lo and behold, let's call it 10 years later, they're 70 years old, Dave passes away. And so now Martha is left. She handles all, of course, the funeral stuff, and no problems there. They had, joint bank accounts. Their checking and their savings were joint bank accounts. So none of that got frozen when Dave died. Martha was able to cover all of the funeral expenses, cover living expenses. But she knows enough to know that now she has to get with a lawyer, and because she heard that she needs to do a probate, which is right. So even though Dave had a will, she's got to go through the probate. In Louisiana, we call it succession. And the reason she has to do that is while she has access to some of Dave's assets, like that joint bank account that they had, like that joint savings account that they had, even Dave's IRA, where she was the designated beneficiary, she got a death certificate to the financial institution, and they moved all of Dave's IRA assets into IRAs in Martha's name. That went pretty smooth, but she's realizing that she can't sell the house. She can't sell the rental property. She can't sell the property on the beach in Alabama or Florida, and she can't access Dave's interest in the brokerage accounts without going through that probate. That stuff is what most people call frozen. Okay, so she comes to a lawyer like myself. What she probably did was she probably called the lawyer who did their wills 10 years earlier. And maybe she did, or maybe she has another relationship that she wants to use. She doesn't have to go back to the lawyer who did the wills. She can use whoever she wants to for these probate or estate administration legal services that she's about to go through. So she goes, makes an appointment with the lawyer. This is maybe 3 or 4 weeks after Dave dies. She brings the will. In the meantime, she's got a buyer for the rental property, and she's ready to sell it. She doesn't want to deal with it anymore. It's a hassle. And so she meets with the lawyer. The lawyer tells her, Martha, I think you know what's going on here. Dave died. He had these assets that were in his name. Even though y'all owned them together, it's his half that's frozen, and you can't sell the rental property until we complete the probate, which is the process, Martha, of going through our court system and getting judges involved. And ultimately, judges will sign court orders ordering that these assets that Dave owned are ordered to be transferred into Martha's name pursuant to Dave's will, where he left his estate to Martha. So Martha says, I get it. And so they start this process of gathering all of the correct, asset information, account numbers, property, legal descriptions, mortgage balances, fair market values of assets, because as part of this court process, us lawyers have to prepare what some people call an inventory, or other people call a detailed descriptive list of assets that Dave owned. So let's say it takes, Martha went into the lawyer's office 3 weeks after Dave died. Maybe it takes 6 weeks for Martha to collect all of the information, to go back and forth on exchanging information between the lawyer's office compiling all of the necessary court pleadings that Martha has to sign. And I will tell you, this is perhaps the easiest of all probate proceeding, because it only involves one person, because Dave left his entire estate to Martha. Now, Dave could have left, here in Louisiana, Martha usufruct and named the kids as the naked owners. He could have left stuff in a trust. He could have left some things to the two kids, Linda and Randy, and in addition left things to Martha. But all of the participants that are, named in the will, all of those people are participants in that probate proceeding. So when we have more than one participant, we got to get them all involved, and they all got to, agree on all of the assets and the debts, and they got to sign off on all of that, and they have to agree on the method of distribution and all of that. And sometimes that gets really hairy when one or more of the participants isn't completely comfortable and may want to question some of that stuff. But in this case, it's about as easy as a probate as it gets. It's just Martha. Yeah, Martha will have to get someone else to sign what's called an affidavit, because the courthouse doesn't accept Dave's death certificate. They want people who knew Dave to sign affidavits attesting to the fact of when he died and what his family circumstances were, and some other information. So there's one other person other than Martha who would be involved signing some of these court pleadings. But nonetheless, they go through a process over a couple of months of compiling all of that data. Fortunately, Martha still had access to the bank accounts, the checking account and the savings account, which were joint accounts. And our most bank and credit union accounts, most of those banks and credit unions do allow that surviving spouse in the joint account to have access to those funds even after the first spouse dies. Completely different story on the joint investment accounts. So if they did have joint investment accounts at any of the investment firms, you name it, there's a bunch of good ones out there, whether it was Charles Schwab or Fidelity or Merrill Lynch or Edward Jones or UBS, Morgan Stanley, TD Ameritrade, Ameriprise. I've dealt with them all. Their rules are different. After Dave dies, Martha's not going to have access, and it depends on the financial institution. At a minimum, they will not give Martha access to Dave's 1/2 community property interest in those accounts. That will be frozen. And in some cases, they will not give access to any of the account. It kind of depends on what the procedures of that particular financial institution are. All right. They take a few weeks. Again, going back to the timeline, Dave died. He was 70. 3 weeks later, Martha meets with the lawyer. They take about 6 weeks compiling information, preparing all of the court pleadings. Martha signs off on all of the court pleadings. Now the lawyer's office needs to go bring all those court pleadings to the courthouse to get them filed. Here's where we run into a problem today. Courthouses are closed. So, if this would have happened and Dave would have died, say, in January of this year, and Martha would have come into the office maybe in early February, and they would have taken maybe 6 weeks or so to get some things prepared. All of it was prepared and signed, in March, and then boom, courthouse is closed. So now all those legal pleadings are really just sitting either on the lawyer's desk, or they were perhaps they were filed. I know some courthouses have some drive-by filing, some electronic filing, but I would venture to guess a judge. In fact, we're in the middle of that with many of our clients right now, and we're not getting any judges to sign any court orders. I heard a few weeks ago there was one judge who was signing various things at the courthouse, and there's probably 10 to 12 judges who handle these kinds of things. But I also heard that one judge really handled emergency matters like criminal matters, temporary restraining orders. Probate can wait, I think is what they're saying at the courthouse. So everything now is in limbo. I realize this is a crazy time, and I'd really rather just talk about what would happen in normal times, but it is really crazy now. So we have several families that are really, really getting frustrated because they have no access to accounts. They can't sell property that they were trying to sell, and potentially even found a buyer to buy, but they can't sell because all of these assets still remain in the name of the deceased person, and they ain't nothing we can do about it. So let's go back to normal times. We file all those court pleadings at the courthouse, and whenever we file them at the courthouse, there's one thing that you're pretty much guaranteed that you're going to do. It's a 4-letter word: wait. You're kind of at the mercy of the courthouse. Our matter, your probate matter, will not be the only matter at the courthouse. Boy, I can't even imagine the volume of courthouse activity coming out of all of this stuff with, quite frankly, all of the coronavirus lawsuits, everybody suing everybody. I suspect that, and with our courthouses opening back up at some point, I heard here in Baton Rouge, not that probate is a judge or jury trial. It is not. But I just read that there will continue to be no judge or jury trials at the courthouse at least through June 30th. So the backlog of stuff at the courthouse, even though probate is not judge or jury trial, stuff is just getting backlogged and backlogged and backlogged, and these delays are going to be just, quite frankly, horrendous. Some of the delays were horrendous when things were normal. I can imagine what it's going to be like down the road. But let's say it was normal times, and maybe let's call it 3 months. It could have been 2 months. It could have been 4 months. But let's say 3 months after all of these court pleadings get filed, the paperwork gets processed, it gets to a judge's office. A judge certainly doesn't read it, but their law clerk, maybe some recent law graduate that they've hired, reviews all the paperwork to determine its accuracy, make sure that the original will, which was filed as part of these pleadings, make sure it meets all of the validity requirements, and what the will says is consistent with this proposed distribution that the lawyer drafted and that the heirs signed off on, making sure all of that is consistent. And then I just have this vision of what happens at the courthouse is that 25-year-old law clerk takes the little Post-it note and puts it on the paper, one of those sign here deals, and presents just a stack of stuff to the judge. Judge signs it, gives it back to the law clerk, and now it's back through the processing department again. And then somehow, either because we keep calling the courthouse and badgering them, or if you have a phenomenal courthouse employee, they actually notify you to tell you, hey, the judge signed the appropriate court orders. Let's get you several certified copies of those court orders so that y'all can present them to these various third parties, and they can take stuff out of Dave's name and put into Martha's name. So we ordered maybe 10 certified copies of the final court order here in Louisiana. It's called a judgment of possession. It's a court order that a judge signs that says generally, I hereby order that the following assets, and we list them: the house, the rental property, the investment account, the CDs, the vehicles. I hereby order that the following list of assets is to be transferred from Dave's name into Martha's name. So we get the certified copies of that court order, and then those get presented either by us or by Martha. She brings them to her brokerage account institution, whether that's Schwab or Fidelity or Merrill Lynch or TD Ameritrade, Edward Jones, you name it. And their lawyers then will review these court orders. And if they're satisfied with the court orders, they will retitle those accounts that were in the names of Dave and Martha, and they'll open a new account solely in the name of Martha and move those prior frozen assets into an account solely in Martha's name. Okay, so, and then we'll record this order in the real estate records of the parish, or in your case, maybe county, where they owned real estate, and that is what retitled the real estate from Dave and Martha, where it couldn't be sold because Dave's not around to sell, to solely in Martha's name. Martha takes another certified copy of this order to the Office of Motor Vehicles, and they will retitle the vehicles that were either in Dave's name or Dave and Martha's name solely into Martha's name. Now she can get rid of Dave's truck or whatever she wants to do there. Now, so you're starting to get an idea of what that process looks like. That's in its simplest scenario, where there's only one participant involved, that surviving spouse. All right, let's see here. And thank you, Tom, for the compliment on doing a good job. Very detailed for off the cuff. Just got to say, not my first rodeo. We don't set up trusts if one lives in another state, Richard. And how much is this costing, Martha? Yeah, very good. So good question, Janice. Normally, I don't address in these kinds of things the how much does it cost scenario, because quite frankly, $1 an hour, my paralegal charges $125 an hour every time we work on, talk to, send an email, read an email, daydream about your matter. You're going to get billed. Another lawyer will say, we're going to charge you X dollars, and whatever it takes. And one lawyer's X dollars could be big number. Another lawyer's X dollars could be big number, and another lawyer's X dollars could be medium number. So, and then there's some say percentage of the estate, such and such, such and such. But nonetheless, given all that, you could talk to 5 different lawyers, get 5 different answers. And quite frankly, you could talk to one lawyer and there could be 5 different circumstances involved. And so that one lawyer could give you 5 different answers. Every circumstance is unique. But let's just be creative here. And before I go into what some numbers might be, I'm going to ask you to hit the like button. Only 9 of you are in that elite status today who have punched the like button. So I want to get more scenario might look like. And I mentioned they had about a $2 million estate. Not that that necessarily has to impact the amount of cost or fees that will pay. They'll pay, because in this scenario, there's no executor's fee. Martha is the executor. She waives any executor's fee that would have been paid from Dave's estate. She waives it because it would be subject to income tax. If Martha receives Dave's IRA, as she takes distributions from that, as it moves into her IRA, and then as she takes distributions, that's taxable income. As she takes distributions from Martha's IRA that she got from Dave, blah, blah, blah. I'm not going to get too much into the taxes. All right. So let's look at some numbers. And thanks, my likes went from 9 to 12. That tells YouTube, hey, show Paul's videos to more people, which is all I'm trying to do here. All right, so let's put some numbers to it. And let's say when Dave and Martha set up their wills when they were 60. Let's say they paid, I hate to even use a number because it could be a lot more or it could be a lot less, blah, blah, blah. But let's say they paid $1,500 to get all of their wills, their powers of attorney, their healthcare documents, their living wills, fair enough to use that as a number. Now, in your circumstances, it could be less and it could be a whole lot more. I'm just using a number so y'all can maybe kind of compare the will trust and the route trust. So when they were 60, they did their wills. $1,500 was $7,500 for Dave for legal expenses to go through the court process when Dave died and have everything transferred out of Dave's name into Martha's name. And there's no real need to change any of Martha's estate documents. Her will already said if Dave predeceases me, I leave my estate to my children and name Dave as executor, Linda as alternate executor. So let's say there's no update expense when Dave dies for Martha's estate planning documents. But then 5 years later, when Martha's 75, she dies. And now you're going through a little bit more complicated probate when Martha dies, because now you have the two children involved. Not only are there more people involved, but there's more activity in the probate because we're not just trying to retitle things. Now they have to sell real estate. Now they have to, the Louisiana probate doesn't transfer that condo that they have on the Gulf Coast. After Dave dies, let's say that condo is in Florida. Martha's got to go hire a different set of lawyers in Florida because the Louisiana probate doesn't transfer out of state real estate that you own. Martha hires another set of lawyers just to get Martha dies 5 years later. Kids got to go through the same scenario. Let's just say because it was 5 years later, they spent $12,500. So when you add up the total legal expense that was incurred to get things set up and to handle the 4 probates, one in Louisiana when each one of them died, and one in Florida when each one of them died. That came to some quick math, 2,000 plus 11,500 plus 12,500. My math indicates that's $26,000. Bear with me, I went to LSU. All right, so that's the amount of the legal expense, and some people look at it that way. Other people look at it in a kind of a, I'm not as concerned about the expense, but I don't want it to be a hassle for people. So if you're in that camp where you're putting some type of cost on the hassle factor, there's a hassle factor of at each death, the family having to deal with lawyers in Louisiana, another set of lawyers in Florida. So there's purely a hassle, a delay, a time factor there, an inconvenience factor. Okay, so that was the will scenario. Now let's fairly quickly go through the trust scenario. You've got Dave and Martha, they're 60. They want to set things up, leave things for each other, then leave it to Linda and Randy 50-50, put Linda in charge. And instead of doing wills, they discover how maybe it would be easier if they set up their die if they're in your name. And yes, I realize there's certain things that you own by their nature, they avoid the probate. Some things which by their nature, they avoid probate. But Dave and Martha realize they have a house, they have a rental property, they have a condo on the beach, they have some joint brokerage accounts. They realize those things don't have beneficiaries, and those things will have to go through probate if they're in their name when they die. So the idea, set up, call it the family trust, call it their living trust, whatever they want to with the trust assets as long as they're alive. The trust, and that surviving spouse can do whatever he or she wants to do with the trust assets, sell, buy, spend, give away, whatever. And then the trust says, like their will said, their trust says that after they both pass away, Linda is the successor trustee, and the two children, Linda and Randy, are 50-50 principal beneficiaries of the trust. So you've got some different terms. With wills, you call them executors. With trusts, you call them trustees. With wills, you call them heirs. With trusts, you call them beneficiaries. And now the key document in their program of who gets what when they die is their trust instead of their will. Their trust controls who gets their stuff when they die. So they set all of that up and they retitle those assets. So they go to those two financial institutions, those brokerage firms, whether that's Schwab, Fidelity, Merrill Lynch, Edward Dees of the Dave and Martha Living Trust. And the lawyer who helped them prepare the trust did the retitling of their home and their real estate into their trust. Again, their rental property, for example, which was titled Dave and Martha, was retitled, and the paperwork was filed in the land records to show Now, so they got all that set up. Probably what it does is call the lawyer and wants to know what she needs to do. And in many of those cases, as long as everything was set up right, the conversation goes, you don't need to do anything. You're the trustee of the trust. You don't need to come into the law office. We don't have to file anything at the courthouse. Nothing's frozen. You just remain in control of everything as the trustee of the trust, and with the trust saying you can do whatever you want to do with the trust asset. So Martha, if you want to put a for sale sign on that rental property this afternoon, go put your for sale sign on there. There's no retitling that needs to take place. You can sell it tomorrow if you find a buyer. So that whole after Dave dies, so there's no, estate settlement expense. Now, somebody posted a comment to a video I did months ago. So let me just address that comment that was made. Under either scenario, if they had more than $11.58 million, there would have been estate tax consequences. Under of either one of these programs, it's more of a, do you want to set things up so that you keep it in your name, but require that your family go through the court process when you die? Or do you want to set up a trust, retitle things to your trust so your family doesn't have to go through the court process when you die? It's not a tax-driven decision. Okay, so she buys and sells things. As she buys and sells, if she buys a new home, she buys it in the name of the trust. If she opens a new brokerage account, she opens it in the name of the trust, so it's not in her name when she dies. She dies at age 75. And now Linda starts looking into what she needs to do to divide up things 50-50 between Linda and Randy, because they were the two 50-50 principal beneficiaries of Dave and Martha's living trust. The trust said after Dave and Martha both die, everything goes to Linda and Randy 50-50. So Linda goes to the brokerage firm, and the brokerage firm looks at the trust and says, well, I see here that now that both of your parents died, you, Linda, are the trustee. And so we're happy to take your direction on dividing things up. We see that the trust says everything goes 50-50. So financial institution says, let's set up an account for Linda. Let's set up one for Randy, and simply just move the assets out of the trust account 50-50. Half into Linda's account, half into Randy's new account. They go outside any court or attorney involvement. When she sells those things, the check will be payable to Linda as trustee of the Dave and Martha Living Trust. She'll deposit that check into a living trust account, and then she'll divide up those living trust account proceeds 50-50 to Linda and her brother, Randy. So if we looked at some numbers there, remember the old numbers, $2,000 to get the will plan set up. I said, let's see, 11.5 to do the two probates when Dave died, 12.5 to do the two probates when Martha died, came to a total of $26,000. Under the trust scenario, let's say they spent, between getting everything set up and getting all the properties in Louisiana and Florida transferred into the trust, there's some additional was not incurred. And then the 12.5 when Martha died with the will expense under the will plan, $5,000 expense under the trust plan. When you look